I'm Drew Stevenson, and this is a lecture about the famous case United States v. Kirby, a U.S. Supreme Court case from 1868. This is about the classic absurdity doctrine, and I have a confession for my students. There's no dog in this case. I just used a picture of a dog with a cowboy to lure you into watching the video. On the other hand, this is a case about the Old West and U.S. Marshals and mail carriers on riverboats and so forth. So let's take a look at what happened in this case. First, here's the big takeaway from this case. This is a famous case about the common law rule of the absurdity doctrine and why the court won't interpret statutes in a way that produces an absurd result. This case it was cited hundreds of times afterwards for the idea that courts should avoid absurd results when they're interpreting statutes, and there's always this outer limit of where we won't go. And so let's look at what happened and what the statute is in this case that the court had to interpret. So Kirby at the time was a U.S. Marshal who executed an arrest warrant for murder against a murder suspect who was actually happened to be a mail carrier, Dr. Ferris, while the latter was transporting mail. Now, Kirby put together a posse which went aboard a mail line river steamship. So these were big river boats that transported mail, but they were also, because they were on time and were big, reliable ships, they were kind of luxury liners going up and down the river. And so they boarded the steamship to arrest Dr. Ferris, who was there with his mail delivery. We're going to find out later at the end of this video that they actually narrowly avoided torching the whole ship. But this delayed the steamship's departure, and it was carrying U.S. mail, so that meant that this shipment of mail was late. Now, we had a federal statute, and that's what's really at issue in this case. And the statute provides that if any person shall knowingly and willfully obstruct or retard the passage of the mail, or of any driver or carrier or any horse or carriage carrying the same, that person was subject to a fine and criminal prosecution. And the federal government prosecuted Kirby, the marshal, and the members of the posse who made this arrest and held up the ship. And so now Kirby argued that he didn't intentionally and willfully retard the mail. The delay was merely incidental to the arrest. So he's basically saying that the mens rea of the statute doesn't apply in his case. The court didn't rule on that, though, on that ground, that is the lack of mens rea. Instead, it invoked the absurdity doctrine and said all laws should receive a sensible construction. By the way, this picture actually is of the boat. You'll see that that's the United States General Buell boat, and it's for discount fare fares on this kind of luxury mail liner, as you can see. Okay. Here's another quote from the opinion. General terms should be so limited in their application as not to lead to injustice, oppression, or an absurd consequence. It will always, therefore, be presumed that the legislature intended exceptions to its language which would avoid results of this character. Now, I want my students to notice this is talking about two different things. One is that courts, of course, should avoid injustice, oppression, and crazy outcomes and things that are shocking and counterintuitive. But it goes a step further and says, we presume that the legislature intended those types of exceptions, or the legislature enacts statutes with the assumption that the court in extreme cases is going to deal with them as exceptions, as exceptional cases. So note that the court presents the absurdity doctrine as a way that courts are faithful to the presumed intent of the legislature. The legislature presumably would not want the absurd result, and it would not have wanted a conviction in this case. But note that this presumes shared values and norms between judges and legislatures. Now, The court admits that it would be illegal under the statute to delay the mail just to execute, let's say, civil process, right? To serve someone with process for a civil suit. But it says arrest warrants are special or different. The public inconvenience which may occasionally follow the temporary delay in the transmission of the mail caused by the arrest of its carriers upon such charges is far less than that which would arise from extending to them the immunity to arrest. And we have a couple famous quotes from Puffendorf and Plowden. Here's a picture of Puffendorf. I couldn't fit all of his hair into my little space for pictures here. And I know, to me, he looks like maybe a member of a heavy metal cover band, but in an often quoted passage, so this is part of the case that's the most famous, the court mentions other examples of absurdity, like the common sense of man approves the judgment mentioned by Puffendorf, who was a legal writer, that Bolognian law, which enacted whoever drew blood in the streets would be punished with the utmost severity, did not extend to the surgeon who opened the vein of a person who fell down in the street in a fit or seizure. In other words, they had a statute in this Italian city that said you can't, we're going to punish people who draw blood in the streets, clearly meaning like injuring people and making them bleed. And that doesn't apply to doctors providing emergency aid. That would be absurd. That then quotes Plowden from the 1500s, who has a much more sensible haircut. The same common sense accepts the ruling cited by Plowden that the statute of First Edward II, which enacts that a prisoner who breaks prison shall be guilty of felony, does not extend to a prisoner who breaks out when the prison is on fire, for he is not to be hanged because he would not stay to be burnt. In other words, we had a statute that you could be punished for trying to escape from prison, but we obviously would make an exception if the prison was on fire and you were going to die if you didn't try to get to safety. So this should raise a question, though, that we can't really answer. What is absurdity, right? There's no such thing as absurdity in the abstract. This is sort of a social construction or social construct. As one commentator defined it, absurdity is extreme departure from the commonly accepted principles of morality, philosophy, politics, or convenience. In other words, what one culture in one century or era might define as absurd might seem within bounds to people living some other place in another time. But laws are applied and courts act within a context, a cultural and social context. And in all of those contexts, there's things that are just out of bounds, that are inconceivable. Now, there's an epilogue or a story behind the story for Kirby. And I hope you've been wondering, like, what were the federal prosecutors even thinking in bringing this case? Why did they charge Kirby in the first place? Well, let's back up, because there was a history between Kirby and Dr. Ferris that goes back to the Civil War. Remember, the case goes to the Supreme Court in 1868. During the Civil War, Dr. Ferris was a Union soldier, and actually with the rank of something called Provost Marshal for the Union in Kentucky, and which was in Gallatin County, was heavily Confederate, and they were supposed to sort of ferret out Confederate organizers and guerrilla factions and things like that. And in 1864, Ferris had actually arrested Kirby for disloyal language and gestures. Kirby had toasted a Confederate war hero and things like that. Later that year, some of Ferris's men conducted a raid. Ferris actually wasn't there, against a band of Confederate guerrillas, which were commonly called bushwhackers. And Kirby's own brother-in-law, John Morrow, was the leader of this Confederate band, and he was killed in the raid. So we get a lifelong grudge between Kirby and Ferris over the death of his brother-in-law. After the war, Kirby himself becomes a U.S. Marshal, but remember, he's still really a Confederate Loyalist. And in 1866, he had impaneled a grand jury, picked most of the people that issued the arrest warrant, and he had filled the grand jury with Confederate sympathizers. And at the time of the arrest, Kirby's posse was really a mob of angry, vengeful Confederate Loyalists who were hunting down Union officers from the Civil War days. And in fact, Morrow's own son, so that's the guy that died in that raid, had vowed to kill Ferris, and he was actually leading the posse, not Kirby. So they go on the boat. There's a huge crowd on shore calling for the boat itself to be burned. They find Ferris hiding on the boat. They and bring him on shore. Some feds show up and rescue Ferris from this mob. Sometime later, he goes to trial, and Ferris is acquitted of all charges. Remember, the murder he's being charged with was an incident that happened during the Civil War, where some Union soldiers found a group of Confederate soldiers and killed them, and so he was being charged with murder. And this actually went on all over the South during the Reconstruction period in heavily Confederate-controlled areas where the local officials were using the legal system to harass and prosecute former Union men in the South after the war, with malicious prosecutions and arrests and things like that. And the Supreme Court actually had none of these facts in the record before it. And due to kind of a weird procedural thing that had happened before even the trial, the parties didn't really want all of these unsavory facts from the war to come in. So both sides stipulated to the facts and agreed that this would just be about the legal question of the applicability of the federal statute to arrests made that delayed the mail. And that was the sole question before the court. So the question is, for my students, does this case not only illustrate the classic expression of the absurdity doctrine, does it also illustrate the dangers of the absurdity doctrine, that sometimes the court is looking at the result and the statute and not asking enough questions about the whole story, like why did we get here, and why do we what's the background here that set us up to something that looks like such an outlandish result. And the court here in their famous U.S. Supreme Court case about the absurdity doctrine actually didn't know any of these facts, and didn't know that Ferris, the one who was arrested, was actually acquitted, and arguably the only murder he had been charged with was something that happened during the war when he wasn't even in town that day. And Kirby was maybe the bad guy in the story, it turns out, and the other members of the posse. So that concludes our lecture about U.S. v. Kirby for my statutory interpretation and regulation class.